what are the main challenges for the application of Sharia. So I'd be looking at, certain aspects. First, the application of Islamic law or Sharia in non-Muslim jurisdictions. That would be my first exploration. The second one would be looking at the different schools of Islamic law or fiqh in the context of Sunni Islam, how these different schools of Sharia are just, different in their own sort of core values and prescriptions, because that would have an impact on the application of Sharia to Islamic financial transactions. And the last one would be sort of wandering around for some kind of universal codification of Sharia for the purpose of regulating Islamic financial transaction or Islamic industry transactions.
I think after issuance of different standards and about the basic practices of Islamic finance and about governance, now we are able to use these Sharia standards as governing law, and or at least as the valid choice of law. And if it is enforceable by law, I'm not clear whether if we apply these Sharia standards, so will it be enforceable by law or not? But I think if it is agreed between the parties very clearly in their original agreement or in any arbitration, subsequent arbitration agreement, that they will abide by these standards as valid choice of law. So yes, these standards can be used as alternative, as regulations for alternative dispute resolution, and as the basis of alternative dispute resolution. And it has capability, these standards have capability to be used as basis and regulation for alternative dispute resolution, provided it is enforceable and it is chosen by both parties as valid choice of law.
Respectful speakers and Mr. Rami, the chairman of the platform. Assalamu alaikum wa rahmatullah. And I welcome also all attendees. Actually, before answering this question, I just want to highlight in one point. Mr. Sheikh Zaman has covered this question well. The first question, how should we face the challenges? Actually, the situation, in my opinion, has been changed since 2009 by introducing and concluding the Rome regulations, which is in the short term and long term. I think there should be legislation to regulate the application of Sharia. As I have said before, in 1989, 18 by the law number 14 of the Central Bank of the UAE.
I believe first, why there is arbitration? There is arbitration because some kinds of cases are very professional and very they deal with very professional issues. And Islamic banking, Islamic products are very professional. And it has been seen through all the core system in England or even among our Arab countries. There are so many problems facing the course in understanding Islamic products. So the only thing here is to go for the available option of going for arbitration. Arbitration is the best. I always say this. It's the best means for settlement of Islamic principles. And if we go back, for example, for the cases, a Shamil case, which has been mentioned earlier, and in that case, unfortunately, the bank did not put the clause for arbitration in proper way. They said the applicable law, the English law, provided that it is not in conflict with the Sharia law. And unfortunately, this opened the room for the judge to say, I know English law, but I don't know Sharia law. Is it a law? Anyhow, later on, of course, this judge was very criticized. And I do remember the judge himself made a comment later on, and he said, I shouldn't have said this because the judge, I should have go and check. So why we need institutional arbitration? Because Islamic finance is very professional, and when you choose the panel or the arbitration panel, you choose it from people who know Sharia law, who know Sharia principles, people from the same sector, people who have been working in this for a very long time, and this is this is a very big step. Now, Islamic finance is booming. Islamic banking is booming. It is increasing very well, and we have to support this. For more booming, we have to have proper means for settlement of disputes. If it is booming, you have to make available proper ways of settlement of disputes. Otherwise, it will be working against the booming. And I strongly believe that we have IICRA as an specialized arbitration center in Islamic finance. I have seen the law, I have seen the regulations, I worked as an arbitrator, and it is well prepared, it is well done, and it is a very good avenue for settlement of disputes in Islamic finance.
One of them is like have the legal background, which is specialized in litigation with sukuk. The other one is more technical professional that is fully aware about the how the issues of sukuk and all the published and the stage of issuance and activities. And the third arbitrator must be familiar definitely with the Sharia aspects of the sukuk. Having like a tribunal with three specialized a person will make the arbitration proceeding. So this is probably why it's fast and efficient. So there is no need to appoint experts from outside the tribunal to give a special opinion probably on any of the subject matter, because the tribunal already is specialized in every single dispute or in the domain of dispute that is like faced in the center. Plus, under IICRA rules, specifically under Article 35, the article set out a mechanism to determine the applicable Sharia provisions. So, and this can be Sharia provision stipulated in the viewpoint of various schools of Islamic or For example, Sharia standards issued by AAOIFI. So this is part of like the rules of ICRA.
I must say that ICRA rules have done a very good job in putting a very comprehensive rules or set of rules to cover the impartiality and independence and the ethics that should guide the work of the arbitrators. When we compare this to other existing rules, for example, if we take the exit rules of arbitration, and we see how much do you talk about the subject of ethics of arbitrators. It is very general and limited. Same thing for the ICC rules. You can only see their focus on impartiality and obviously of competence. But if we go to the ICRA rules, we find that it is far more reaching and comprehensive.